to the substance of your allegation, could you please substantiate the grounds for standing before the court?
The applicant submits that we have jurisdiction in regards to the compulsory ipso facto in article, as provided by Article 36, paragraph 2 of this core statute. Both Apropluia and Ranofsaio are signatories of the international health regulations and have committed to abide by its provisions. Article 43 of the IHR provides that in order to respond to a public health emergency of international concern, states may only implement additional measures if such measures are supported by public health rationales, scientific principles and evidence, or WHO's guidelines and advice. In the case at hand, it is clear that most of the travel restrictions enacted by Ranofsaio's entry regulation were not supported by a strong and sound public health rationale, nor scientific data, and much less WHO's guidelines and advice. Indeed, the Health Ministry of Ranofsaio merely announced that he would conduct an intensive study based on the best scientific evidence available. There was, however, never any substantiation as to what such evidence consisted in, nor on its sources, and much less on the basis of which parameters it was deemed to be the best.
Agent, is such substantiation of scientific evidence required under international law? And if so, what source should this court rely on for a definition or understanding of scientific evidence?
Your Excellency, scientific evidence is defined in Article 1 of the IHR as the information furnishing a level of proof based on the established accepted methods of science. Moving on, a 2006 study on the...
Agent, in that definition, there's no specificity as to what level of scientific evidence or what level of proof is required. Why can't this court simply rely on the fact that the respondent country undertook a study? Why is that insufficient in your view?
For scientific evidence to be sufficient to support additional measures, it must not be more restrictive of international travel, more invasive, or more intrusive than the alternative measures available. And the applicant submits that there were alternative measures available, such as the temporary measures that were issued by the WHO on the 20th of April of 2018, such as social distancing, the use of face coverings in areas that were reporting infection, and the self-quarantine for 14 days if experiencing symptoms of COVID-19. A 2006 study on the highly pathogenic Asian avian influenza found that while flight restriction may delay the spread of diseases, they do not eliminate the risk. Thus, Ranofsaio's travel restrictions
But don't you think that on the basis of the information available at the time, it was reasonable for the respondent to take some preliminary measures in order to mitigate the spreading, even if this is not completely effective in order to stop the spreading? It could still be considered as a first attempt under the circumstances in which the situation is very uncertain.
Your Excellency, it is true that it is within a state's sovereignty to issue additional measures, but because Ranofsaio, by agreeing to the international health regulation, has consented to voluntarily limit its sovereignty in regards to the issuing of additional health measures in situations of an outbreak, that certain protocol must be followed. And because such protocol was not followed in this case, the applicant submits that there is a violation of international law in Article 43 of the IHR. The Ranofsaio's travel restrictions to reduce the spread of COVID-19 were actually contrary to the scientific evidence available on disease transmission at that time. Moreover, the applicant submits that the study itself is questionable regarding only a month had passed between the outbreak and the issuing of the study. In addition to
in this respect, should we take into account the information available at the time, or should we take into account, should we adopt an ex post perspective on the information available?
Your Excellency, the applicant submits that facts that happened in the past should be assessed with information that was available at the time the facts happened. It is true that a large number of states regarding COVID-19 have issued additional travel restrictions, and it is true that those restrictions are in contrary to what is provided by the WHO and in contrary with Article 43 of the IHR as well. One must not forget that the aim of the IHR is to provide a public health response to the international spread of disease while still avoiding unnecessary and unjustified interference in international trade and traffic. Furthermore, the regulation also contravenes WHO's guidelines. Only through the
Council, before we move on to the guidelines, could you please explain for us exactly what aspect of Article 43 of the regulations you contend has been violated here?
The applicant submits that the protocol addressed in Article 43 was not was enacted. The WHO actually sent a communication to the Khan of Stein Ministry of Health, recalling that the Ministry of Health would reconsider the application of the entry regulation. Furthermore, imposing restrictions solely based on nationality, as the entry regulation of Khan of Stein does, is subject to an appearance of an unjustified discrimination. There's a weak correlation between nationality and exposure to the virus.
Agent, I'm sorry, but I do not see how this measure could be discriminatory to the extent that, of course, there is a carve out for nationals of the state, taking into account possibly Article 12 ICCPR. But besides that, there is no sign of discrimination in the way in which the entry restrictions were formulated. Could you please address this point specifically?
The applicant submits that the entry regulation was in fact discriminatory, since it prohibits non-nationals that were in high-risk countries from entering the state, differentiating from the clandestine nationals that are submitted to an 18-day quarantine, as we can see from paragraph 10, where the entry regulation is reproduced.
Yes, Agent, but you would concede that Ranovstayo was obligated, in light of its obligations under ICCPR, to accept its own nationals. They could not stop their nationals from entering the country.
The applicant submits that there were other ways in which the additional measures could be efficient, such as risk communication, surveillance, patient management, and screening at entry and exit.
What I'm missing in your speech is how these measures were discriminating against other individuals, because admitting that there were other measures that could have been potentially adopted, the approach chosen by Ranovstayo applied in the same way to everyone who was a non-national. So where is the discrimination here?
The applicant submits that there is discrimination, since under Article 12 of paragraph 4 of the ICCPR, no one shall be deprived from the right to enter his own country. CCPR comment number 27 in paragraph 20 states that the wording of the article does not distinguish between nationals and aliens, and it permits a broader interpretation that might embrace other categories of long-term residents. The committee also submitted that there are few, if any at all, circumstances in which deprivation of this right can be reasonable. Moreover,
so, Agent, you are now arguing that the measure was discriminatory against permanent residents?
The applicant is submitting that if there were permanent residents that were not of Russian of Khanofsayan nationality, then there were that they were discriminated against by this entry regulation. Considering that whole life
is this any of these individual of Upper Pluvian nationality?
I'm sorry, could you be so kind to repeat the question?
Sure. Is any of these individuals who are potentially permanent resident, non-national, of Upper Pluvian nationality?
It is not stated in the statement of agreed facts that there were residents of Upper Pluvian within Khanofsayo's territory, but one can assume, because of the proximity of the two countries, that there were in fact Upper Pluvian nationals with residents within Khanofsayo's territory.
Well, the reason why I'm asking you this is getting back to my initial question about standing. Why Upper Pluvian is claiming now a violation, on which grounds, considering that if a discrimination occurred, it's not even sure that affected your nationals. So why are you here today? Why do you even care about this?
The applicant is seeking compensation. What is stated in the prayer for relief is that Upper Pluvian is seeking that Khanofsayo compensates for the economic losses in consequence of this entry regulation. The applicant submits that the answer to the question of compensation is twofold. Firstly, the applicant will address the prayer for relief, which is actually the need for compensation for economic losses. And then the applicant will demonstrate that there is a direct link between Khanofsayo's wrongful act and Upper Pluvian's economic losses. Upper Pluvian requests the court to adjudge and declare that Khanofsayo violated international law by applying its entry regulation to Upper Pluvian and is thus obligated to compensate for the resulting of economic losses. Regarding the Arziwa, the requirements for a causal link between the wrongful act.
Agent, has this court ever awarded compensation in similar circumstances? That is where there's been a measure implemented for health reasons?
The applicant did not address the court in this matter. Your Excellencies, the applicant submits that the Khanofsayo's entry regulation was a necessary element sufficient for the occurrence of economic losses. As it is stated in the Statement of Agreed Facts, paragraph 30, almost 80% of the tourists in Upper Pluvian left the country. And according to Upper Pluvian's border officials survey, 2/3 of those left stated that the primary reason for their departure was that the application of regulation.
Can we attribute the losses only to those 2/3 of people who left the country immediately when before introducing the restrictions? Couldn't a large portion of the losses, or maybe all of them, be attributed to the overall effect of the outbreak from the disease? People just not wanting to travel to your country.
Your Excellency, as we see from the Statement of Agreed Facts, the outbreak started in April, and this survey was conducted in June after the outbreak and after the issuing of the Khanofsayo's entry regulation, which means that these 80% of tourists that left Upper Pluvian were in fact leaving.
Do you have evidence that but for the travel restrictions of Ravnostayu, you would not have incurred those economic losses? Can you say this with certainty? Or would still substantial amount of losses have occurred due to the outbreak of the disease and people just traveling less?
Your Excellency, more than the but-for test, one can actually submit the NEST test, and the applicant submits that in fact Khanofsayo's entry was a necessary element of a sufficient a sufficient set of elements for the occurrence of the economic losses. Your Excellencies, if it pleases the court, the applicant will now address the issue concerning Khanov Sayu's failure to hand over Ms. Kleinblatt to the Appropriate authorities. In this regard, the applicant would like to submit that Ms. Wormond does not fit the definition of refugee under the 1951 Convention relating to the status of refugees. Not only does she not fulfill the 5 requirements to be eligible for...
Is it necessary for someone to qualify as a refugee in order to get some form of temporary protection?
No, Your Excellency. In this case, the applicant submits that there is no right to grant diplomatic asylum. Therefore, the only way that Ms. Wormond would be eligible for such a status was if she were to fulfill the 5 requirements under Article 1 of the Convention relating to status of refugee. The applicant would like to submit, therefore, that regarding the demand for a well-founded fear, Ms. Wormond failed to offer credible, direct, and specific evidence that supported such fear. Your Excellency.
But Agent, I'm sorry, but you sort of give for granted that diplomatic asylum does not exist. But probably you would need to convince us of your position in this respect.
Your Excellency, it is stated in the Aya de la Torre case that diplomatic asylum derogates territorial sovereignty of the receiving state. So this form of asylum can only be granted or recognized as legal under international law if there's a legal basis for it to which both provided by a convention to which both states must be parties. In this case, no such agreement existed, so there is no legal basis for the granting of diplomatic asylum. Moreover, the applicant submits a UK Court of Appeal on B and others versus the Secretary of State of the Foreign and Common Health, which states there where the receiving state requests the fugitive to be handed over, the situation is very different. The basic principle is that the authorities of the receiving state can require surrender of a fugitive in respect to whom they wish to exercise authority. Where such a request is made, the Convention on Consular Relation cannot normally require diplomatic authorities of the sending state to permit the fugitive to remain within the diplomatic premises in defiance on what's provided by the receiving state. The applicant submits that the refusal to surrender Ms. Wormond is an obstacle to Appropria's right to prosecute its criminals, and it cannot be excused by invoking a supposed duty to protect human rights. Khanov Sayu had no legal basis with which to obstruct the due course of justice and to interfere with another state's legitimate decision to prosecute its nationals.
Could you please clarify on which basis, sorry, I think I'm having a problem with the microphone. Could you please clarify for us whether Khanov Sayu had an actual obligation to return Mrs. Wormond, and if so actively return her, and if so, what is this legal basis?
The applicant submits that concerning Article 55 of the Vienna Convention on Consular Relations, the consular post must be respectful of the receiving state's laws and provisions. In this case, the applicant submits that the consular post was not respectful of the receiving state's decision to prosecute its national who stands accused of criminal behavior. Because there was no prosecution in this case.
What is the criminal behavior at issue here? Isn't the issue the violation of a commercial agreement, a non-disclosure agreement?
Your Excellency, Ms. Wormond stands accused or charged with 3 offenses under the National Criminal Code of Aproplia. The first one being the causing public disorder, the second one the violation of a non-disclosure agreement, and the third one being the interference with the police investigation. The applicant would like to submit that Aproplia is a democratic state that respects human rights and the rule of law, and Ms. Wormond signed the non-disclosure agreement, the violation of which constitutes a crime under the National Criminal Code. Moreover, Ms. Wormond was not arbitrarily detained. Furthermore, there is nothing in the Statement of Agreed Facts that indicates that her right to due process was in question. She would still have the right for an impartial court to be informed of the nature and cause of her accusation, and the right to appeal the decision. I see that my time is up. May I please conclude my submission?
Yes, you may.
Thank you. May I refer your excellencies for the balances of our submissions. Thank you for your time. May it please the court. Thank you very much.
Thank you. Ms. Grande. Please proceed whenever you're ready.
Thank you. Your Excellencies, Mr. President, honorable representatives of Anavstayo, may it please the court. My name is Carolina Grande, and I'll be representing the applicant. I'll speak for 22 minutes. As my co-agent Leonor Ferreira stated, I'll be addressing the issue of the court's jurisdiction over the respondent's counterclaim. Subsequently, I'll address the question of whether there was or not a violation of international law in the shooting down of the aircraft. Your Excellencies, our first submission is that this court has no jurisdiction over the counterclaim. First, the applicant's reservation in its acceptance of the ICJ's jurisdiction is valid and operates in this case. Moreover, the applicant submits that the shooting down of the aircraft was a military activity and is therefore covered by its reservation. Moving to the first basis, Article 36 of the ICJ statute in its paragraph 2 determines that a declaration is a unilateral act by which a state accepts the compulsory jurisdiction of this court. This act establishes both the relationship between the state and the International Court of Justice and the state, the declared state, and other states. Considering that the nature of the jurisdiction of the court is strictly consent-based, states are free to include reservations to their declarations. Article 36.
Agent, I'm particularly concerned about the specific wording of your reservation to the extent that it may appear as limiting the competence of this court to decide on whether it has jurisdiction or not. Could you please address this point also in the perspective of the effects of this on the scope of review of the court?
Yes, Your Excellency. Our submission is that within the limits, and that our reservation is an expression of the sovereignty of our state, and it's also an expression of the consent-based characteristic of this court's jurisdiction. Therefore, our submission is that the reservation present in this case seeks to the determination that the state makes is sufficient to determine that this court has no jurisdiction over this case. In fact, the reservation in the present case seeks to safeguard matters which are essentially within Apulia's national concerns. Therefore, this court should be limited to identifying that the state has made a determination under its declaration that is valid. Yes, Mr. President.
Yes, I'm just wondering, is there in the record a declaration on the part of the applicant finding that this is indeed a matter that falls within its domestic jurisdiction? Is there some instrument that reflects that determination?
Your Excellency, there is no declaration within the Statement of Agreed Facts. However, the applicant is now making a declaration that this court has no jurisdiction over the counterclaim, and this consists in our prayer of relief in this particular case, especially since this is...
Excuse me, can you please explain the basis under international law for the counsel team for the applicant to make formal determinations on behalf of the state?
Your Excellency, in this case, the reservation operates in regards to a counterclaim reduced by the respondent team, it would only be natural that this declaration is invoked within the proceedings before this court. However, even if this court denies the self-proclaiming or the automatic aspect of this reservation as valid, we would still submit that this case, the counterclaim consists in a military activity and is therefore still covered by the applicant's reservation. Indeed, although there's not an undisputable definition of military activities in international law, the International Tribunal for Law of the Sea on the case concerning the detention of 3 Ukrainian vessels affirmed the military generally refers to the state's national security interests against external threats.
Agent, I see a potential conflict between your interpretation of the reservation, because on one hand you try to convince us that this was a domestic matter, a purely internal matter, and now you're trying to convince us that this was a military activity. But military activity is normally something that aims at protecting the state against a foreign threat. So affects or may affect the domestic dimension of your claim that this is a purely domestic matter. How do you reconcile these 2 elements?
Your Excellency, I'll answer your question in 2 points. First, I apologize if I didn't make myself clear in our first submission. However, it is the applicant's interpretation of the reservation that both military activities and domestic matters can be determined as such by the government of Upper Puglia. In this case, what we are invoking that this was a military activity and is therefore covered by the automatic aspect of the reservation, because a determination has been made to this effect. However, our second submission is a subsidiary argument in the case that this court does not accept the automatic aspect of this reservation.
Agent, I'm sorry. Oh, go ahead. I need a clarification. When you say the automatic aspect, you mean the self-judging aspect, meaning that you have made meaning that applicant has made a determination conveyed to us here by counsel, by agent, that this is a matter of an exclusively domestic matter as determined by the applicant. Is that your position on this point?
Your Excellency,
I just need a yes or no answer so I can ask my question.
I'm sorry, Your Excellency. It's a matter I'll have to explain briefly because.
Well, let me ask my question again. Let me ask my question again. Has applicant made a determination that this incident is a matter of its exclusive domestic jurisdiction?
The applicant submits that this is a military activity as determined by the government of Upper Puglia. So we submit that our reservation when it refers to the determination, the automatic aspect refers to both situations, both the military activities and essentially within the domestic concern.
Leave aside the military activity for a moment. Is it your position that this incident is within your exclusive domestic jurisdiction as determined by the applicant?
Yes, Your Excellency.
In that case, as you know, Article 36 of the Statute of the Court requires reciprocity.
Yes.
Could the respondent then use your reservation and make a determination that the measures it has taken to protect the health of its population are within its exclusive domestic jurisdiction as determined by respondent?
Yes, Your Excellency, it is our understanding and that of this court, as in the case of certain Norwegian loans, that the respondent could invoke in a reciprocity aspect the self-judging clause. However, they failed to do so in the present proceedings. Therefore, in moving on to the military aspect of those facts in cause here, as accepted by both parties, the aircraft that shot down the civilian Mayton Airways aircraft was part of Abrupluya's Air Force and commanded by a member of the state's military personnel.
Agent, if we accept that there was a military exercise, does that mean that the Chicago Convention applies here? And if the Chicago Convention applies, should this court defer its jurisdiction to the body named in that convention?
Your Excellency, it is our submission that the Chicago Convention is not applicable in this case under Article 3A of the Convention, where it states that this convention is only applicable to civil aircraft, and it excludes actually in the subsection B state aircraft from the applicability of the reservation, of the convention, I'm sorry. Indeed, most importantly, in this case, whether an activity is considered military or not ultimately depends on its purpose and intent. In fact, the interception of the Mayton aircrafts was an act conducted by the military personnel that seeks to prevent an armed attack. It is then clear that this incident concerned military activities and is therefore covered by the applicant's reservation.
I'm sorry, Counselor, you said armed attack. What were the arms aboard the airliner?
Your Excellency, there were no arms aboard. However, our submission is that this attack, for its purpose, should be made an analysis, an ex-ante analysis, in the belief of the military personnel of Abrupluya that directed all the Air Force to prevent what they believed was to be an armed attack under good cause, namely because there was a warning by Interpol, as can be seen in paragraph 38 of the Statement of Agreed Facts, that there was going to be a bomb-laden attack through a civilian aircraft directed at the state's capital. And all of these facts were repeated in this incident, what we led to believe that this was an armed attack, an ongoing military attack.
Agent, do you use the term armed attack in the sense of Article 51 of the UN Charter?
Yes, Your Excellency. And if I may proceed to my second submission on this.
Well, let me ask you a question about that. Article 51 of the UN Charter says an armed attack against a member state. It implies by another member state or by a foreign state. I have a legal question and a factual question. The legal question is, do you understand the term armed attack to mean armed attack not only by a foreign power, but also by internal forces? And two, as a factual matter, what is your factual support to say that this was an armed attack against a member state, meaning against the applicant, under Article 51?
Your Excellency, if I may address your first question regarding internal, an armed attack against an internal forces, this is not, and to clarify, this is not a submission. As it is understood by the applicant that this was an external threat. However, it was a non-state actor. It was an external threat opposed not by a state, but by an international terrorist organization that had or claimed to have cells in over 100 countries and had been on the United Nations Security Council consolidated list of terrorist organizations.
Well, okay, but does Article 51 apply to an armed attack by a non-governmental entity?
Your Excellency, it is our submission that this court, in letter of Article 51, is not limited to acts attributed to a state, we bear in mind the jurisprudence of this court, and what we will demonstrate is that there was a shift in international law considering the power and the magnitude of recent attacks by non-state actors and terrorist organizations as the friend of justice organizations, in this case, opposed to states. Indeed, states cannot be helpless in the face of an armed attack by a non-state actor, which opposes such a threat as big and as powerful as a state can oppose to its citizens, to its sovereignty, and to international peace as in general. It is our understanding and that of the United Nations General Assembly and the United Nations Security Council that although the Charter was historically concerned with interstate relations, that non-state actors oppose a big, dramatic change and an increasing threat in the modern world. In light of recent events, Your Excellencies, we argue that the ICJ, although the ICJ maintained its position expressed in the Nicaragua judgment that only acts attributed to a state can constitute armed attack, this has not been the state practice. Moreover, we argue that in light of recent developments, not only state practice, but also the accompanying opinion units has seen a shift in the traditional understanding. Indeed, immediately after the events of 9/11, the United Nations Security Council adopted Resolution 1368, which explicitly recognized the inherent right of self-defense of the United States of America.
Agent, assuming that this was an armed attack, was your reaction proportionate to the threat posed by the plane?
Yes, Your Excellency. It is our submission that the reaction by Apropluia's officials respected all the limits of self-defense, and that is of necessity and proportionality. Regarding proportionality, what it means is that a threat posed has to be superior than the force used to prevent the attack. And in this case, not only did Apropluia's officials take all possible precautionary measures before shooting down the aircraft, the shooting down was also aimed to only prevent the aircraft of moving forward, and was not aimed to causing the loss of life of the two women aboard. However,
Agent, if I have my facts correct, the shots were aimed at the wing of the aircraft. Now, I don't know much about aviation, but that would seem to be a pretty essential part of the aircraft. On what basis do you make your argument that this was a non-threatening way of attacking the aircraft?
Your Excellency, it is stated in the Statement of Agreed Facts in paragraph 42 in the commanding officer's report that the officials involved in the operation intended to merely intercept the aircraft. However, we would argue that it's also understandable when an aircraft is only 3 minutes of flight away from the capital of the city, posing a threat not only to the lives, but most importantly to peace and sovereign integrity of the applicant state. That all precautionary measures were taken, that this aircraft had been intercepted. Indeed,
the organization in question, I believe it's called the Friends of, you'll correct me if I'm wrong, but the Friends organization, had they ever made such an attack before? Have they ever attacked you using civilian aircraft?
there is no evidence in the Statement of Agreed Facts of a previous attack using a bomb-laden civilian airplane. However, the Friends of Justice organization have been responsible for multiple attacks in several capitals around the world, as can be seen in paragraph 39 of the Statement of Agreed Facts. And even in also one thing that led of the police officials to believe that there was an imminent attack in this case, and had a very good cause, was the fact that Interport had warned only a week before, as can be seen in paragraph 38 of the Statement of Agreed Facts, that there was going to be an attack in using a civilian bomb-laden aircraft directed at a capital city of either Avropluia or Hanovstal. This led Avropluia's officials to be in high alert for such an attack, using these characteristics specifically.
Agent, if, let's assume we accept all of that, and the country that you represent was on high alert, why did they allow planes to take off at all? Why didn't they simply ground all aircraft in the nation if they were a threat of armed attack, or take other measures in advance of, of shooting at the aircraft? And the fact that your country didn't do that at all, would we take that into account in making our decision, whether there was sufficient precautionary measures before shooting at the aircraft itself?
Your Excellency, first, Avropluia would never go against its obligations under the Chicago Convention of authorizing civilian aircraft to go over its airspace. And most importantly, I should remind this court that only aircrafts operating evacuation flights were operating from the secure airport at this point.
Agent, but if I may follow up on my learned colleague question, what I see from the pattern of the facts is that we have a situation in which two individuals managed to enter an airport, no one stopped them. They managed to steal a plane, no one stopped them, and managed to leave undisturbed. So if you put in place sufficient measures in order to control the situation on the ground, the shooting of the aircraft could have been prevented. And this is where I have doubts about whether you took all possible measures to avoid getting into the situation.
Your Excellency, I'll briefly respond to that as my time is running out. In fact, both the airplane supplier was a private operator, and therefore is not within the power of Avropluia government to exclude it or to not permit it of taking flight from a private airport. Finally, I'll refer Your Excellencies to our memorials for further submissions. I'll thank you all for your attention. May it please the court.
Thank you very much, Counsel. May we now hear from the respondents, please? Who will be taking the floor for the respondents? Please, Ms. Yunus, you have the floor. But I believe that your microphone is on mute. Oh no, now it's not.
Hello, am I audible? Thank you, Your Excellencies. Your Excellencies, good day. My name is Wardah Yunus, appearing on behalf of the respondent, the Republic of Hanovstal. Together with me is my co-agent, Ms. Amira Batrisha. For the next 22 minutes, I will be submitting on the first two grounds in response to the applicant's submission, which are firstly, the respondent did not violate international law by applying its entry regulation towards the applicant and is therefore not obligated to compensate the applicant. And secondly, the respondent did not violate international law by refusing to hand over Ms. Vorman to the applicant authorities. Your Excellency, we shall now move on to our first ground of response, which are firstly, the respondent did not violate international law by applying its entry regulation towards the applicant. Your Excellency, the applicant had earlier submitted that the respondent violated international law, particularly Article 43 of the International Health Regulations, because the respondent did not act in line with the available scientific evidence at the time. However, Your Excellency, we respectfully disagree with what has been put forward by our learned friend, because, Your Excellency, we submit that the respondent's measures were justified by the precautionary principle rule, and that is what has been correctly pointed out by Your Excellency Agnes earlier. Your Excellency, at times of pandemic such as this, there is undoubtedly uncertainty surrounding the current medical circumstances, and this is where the respondent can take precautionary measures in order to safeguard against uncertain risk. And this, Your Excellency, is in line with the case of United Kingdom and Ireland and European Commission, where in that particular case, the court mentioned that at times of public health concerns, a government can take precautionary principle. Yes, Your Excellency, Kristen. Okay, my apologies.
Please go. Well, actually, I was going to ask a question. Was that case decided under international law, or was it decided under European law?
Your Excellency, in that particular case, it was decided under European law. However, the relevant principle that we wish to highlight before this court and is relevant before the ICJ would be that when, at times of public health concerns, Your Excellency, the state is warranted to take precautionary measures because in order to safeguard against the uncertainty of the risk at the time when the measure was taken. And this principle, Your Excellency, we plead to the court to extend its application by the ICJ, because in this present case, yes, Your Excellency, and in this present case, it does involve a matter of uncertainty, and we would like to refer the court to paragraph 23 and 27 of the Statement of Agreed Facts, where in our particular case, there was at least a 12-hour gap between the applicant confirming that they have 2 cases and the applicant's subsequent measures to implement lockdown and mandating face covering and social distancing in their territory. What we wish to submit, Your Excellency, yes, Mr. President.
Well, just a question about this precautionary principle. So I'm familiar with the Articles on State Responsibility of the International Law Commission, which talks about excuses for what would otherwise be breaches of international law on the basis of necessity and similar factors. But I don't recall seeing a reference to the precautionary principle in the ILC draft articles. Are you arguing for an extension of the law beyond what was recognized by the ILC 20 years ago?
Your Excellency, Mr. President, we respectfully disagree because the respondent is not invoking a defense because we do not believe that we have actually breached the law in the first place. Nevertheless, the precautionary principle, Your Excellency, is also recognized under the WHO, although not expressly provided under the IHR itself. Nevertheless, Your Excellency, the WHO recommendations which the applicant relied on are not binding in any way towards the respondent, and the respondent is allowed to take measures which are beyond the recommendations on the condition it fulfills the proviso of Article 43, Clause 1 of the International Health Regulations. Yes,
Agent, but don't you have at least an obligation of cooperation, both with the WHO itself and, in this case, with the applicant?
Your Excellency, as far as cooperation is concerned, we submit that the respondent did indeed cooperate with the applicant when they did meet with the applicant to discuss on these certain measures that they have taken under paragraph 23 of the Statement of Agreed Facts. Nevertheless, Your Excellency, as important as cooperation is, the respondent is justified to take its measures under Article 43, Clause 1 of the International Health Regulations, as long as...
Just before we leave this topic of cooperation, one thing that bothers me when we talk about this topic of cooperation is if we look at the second paragraph of the regulation, It applies to countries that have been designated high-risk countries, and there's no defined criteria. That is, the applicant state would have no way of knowing when the regulation would apply or not apply, which gives me some discomfort. Can you address that discomfort?
Your Excellency, if we may clarify your concern, under Section 3 of the regulations itself, it did provide that when there are a minimum of 50 cases in that particular territory, it will be regarded as a high-risk country. Now, we understand Your Excellency would be wondering about why we did implement the measure when they have only recorded 9 cases. And this is where we submit, Your Excellency, that the respondent is entitled to take precautionary measures at times of uncertainty due to the fact that although the applicant says that they managed to control, at any point in time, the fact they did manage to control the spread of this COVID-18 in their territory. However, the respondent takes due regard to the fact that there was a 12-hour gap between their confirmed cases and the measures that they decided to take. Within those 12 hour gap, Your Excellency, the respondent is uncertain if this COVID-18 has indeed spread beyond its borders, and we submit that at the end, in the clarifications, it did provide that the applicant's cases just kept increasing until it surpassed a 2,000 mark, Your Excellency.
Could I just ask, you made reference, if I understood correctly, to an internal law of the respondent concerning the number of cases required in order for a country to be a high-risk country. What's the relevance of that to the issues under international law that we're required to decide here today?
Thank you, Your Excellency. Thank you, Mr. President. The relevance is that the respondent, Mr. President, is having sovereign powers under the IHR to enact any particular legislation to combat this COVID-18. However, we do acknowledge that there is a limitation to this under Article 43, Clause 1, which is the respondent cannot take such measures if there are other reasonably available alternatives and if it can achieve the appropriate level of health protection. To which, Your Excellency, the applicant earlier submitted that there are actually other reasonably available alternatives, and they cited the WHO recommendations for the purpose of suggesting those alternatives, which are for the use of face covering, social distancing, and quarantine. Nevertheless, Your Excellency, the respondent submits that these alternatives, although they look very nice on paper, but in practice, Your Excellency, these alternatives are not actually sufficient to combat this COVID-18 in order to achieve the appropriate level of health protection in the respondent's territory, which is why the respondent had to take this entry regulation towards the applicant, and it is proven to be effective as stated under the clarifications, Your Excellency. Your Excellencies?
Agent,
Yes, sir.
before we discuss with the applicant the fact that this measure was discriminatory, not only with respect to the way in which it was implemented, but specifically with respect to the fact that it applies to permanent residents of your country. And I would like you to address this point in your submissions.
Thank you, Your Excellency. Your Excellency, Agnes has also pointed out earlier regarding whether there was actually discrimination when the respondents' measures distinguish between their nationals and also the permanent resident status, Your Excellency. However, what we wish to highlight before this court is that the legal position that the court has to consider is that the respondent owes a duty under the ICCPR to allow the entry of their own nationals under Article 12, Clause 4 of the ICCPR. And however, Your Excellency, this does not mean that the respondent also owes the same duty to the permanent residents, because, Your Excellency, to interpret the meaning of own country, returning to one's own country, there are cases that has set a very high threshold to determine what exactly does own country mean. And we refer this ICJ to the cases of Warsim in Canada, whereby in order to establish that the person is belonging to that country, that person has to establish that they have special ties to that country and not merely having a residence in that country, Your Excellency.
But in this case, when we're talking about permanent residents, we can imagine a situation where there are people who have jobs, who have families, who maybe lived in that country for their entire life. So I would not be that fast in dismissing the ties that these individuals have with your country, irrespective of whether they are formally citizens or not.
Indeed, Your Excellency, we agree that there is a possibility. Maybe they have lived all their lives in the respondent state and therefore they have special ties to the respondent state. However, Your Excellency, we would like to echo what Your Excellency Agnes has stated earlier, that the facts are actually not stating as such, because under paragraph 45 and paragraph 30 of the Statement of Agreed Facts, it does not mention that the permanent residents were barred from entry into the respondent state, and in fact, it only mentions that the nationals are coming back to the respondent state, which is unclear to which state do they belong to. And nevertheless, Your Excellency, at paragraph 45, the applicant is concerned about the permanent residents within the respondent state not being able to go out of the respondent. Now, to this, Your Excellency, we submit that in itself is not a restriction to their right to return to their own country, because they are already in their own country, if that is the definition.
Agent, may I refer you to section 5 of the entry regulations, where it's clearly stated that non-Ranostaya nationals also are non-Ranostaya nationals with permanent residence in Ranostaya are also banned from returning.
Your Excellency, under section 5, it mentions that non-Ranostaya nationals, including Your Excellency, in this particular case, we would like to highlight that although the respondent acknowledges that there is a problem of conflicting rights in this particular case, on the one hand, the respondent has to provide for the rights of public health, but on the other hand, it involves the right to private life of these family members, Your Excellency. And to this, we submit that the respectable ICJ can draw inferences from the case of Dudgeon and United Kingdom, where in that case, the court held that in order to determine which right should prevail, the court will look into which right requires a more pressing need, which in this particular case, Your Excellency, the respondent submits that the right to public health is what matters more urgently at this point in time compared to the right to private life, Your Excellency. Your Excellency, before we move on to our second ground, we would also like to address on the issue of compensation, that even though in any case, if the respondent is found to be liable towards the applicant, we would like to note, based on what Your Excellency has mentioned earlier, that it is not necessarily because of the respondent's travel regulation that they have lost their income. And this is because there are many other reasons why they could have lost their income.
Agent, what is the value that we should attribute to this survey that was conducted at the airport with respect to the outflows of tourists?
Yeah, the value that the respondent submits is that we plead to the court to accord not so high value, probative value to this survey, due to the fact that it is only conducted by their own government, and there may be issues of impartiality to the survey, Your Excellency. And in any event, Your Excellency, what we wish to submit is that their losses have to be attributed to the respondent's conduct based on the case of Charles Factory, Your Excellency. But in our present case, that is hard to be deduced because of the fact that at times of pandemic, there are so many other reasons why a state would sustain losses, economic losses, and this is one of them when tourists themselves are reluctant to travel into the applicant state, and because of the fact that the applicant state is also dealing with this pandemic, and that would take a toll on their own economy, Your Excellency. Your Excellency, if there are no further questions. Yes, Mr.
Well, one quick question. there's a clear correlation between the entry regulation adopted by the respondent and the losses suffered by the applicant. I mean, clearly, there was the entry regulation, and then thereafter there are the losses that suffered the applicant's economy. Why isn't that enough?
Yes, you see, the fact that there is a clear correlation itself may not be sufficient to prove that their losses are because of the respondent. And to add to that, Your Excellency, we need to highlight, the respondent highlights before this court that the travel ban itself, the entry regulation itself, was implemented due to the delay by the applicant in implementing its measures. Had they implemented their measures urgently and managed to contain the virus within their Segura province, as how they have claimed, then this measure by the respondent would not have actually been taken, Your Excellency. Thus, what the, yes, Your Excellency. Oh, my apologies, Your Excellency. Thus, we submit that the losses which they claim to have suffered is not attributable to the respondent. Mr. President and Your Excellencies, we shall now move on to our final ground of response, in which the respondent did not violate international law by refusing to hand over Ms. Vorman to the applicant authorities. Your Excellencies, the applicant submitted that the respondent had violated...
Before you proceed, I have a general question. The applicant before mentioned the fact that there is no possibility to grant political asylum unless Mrs. Vorman was a refugee. And I was wondering if you could clarify for the court what is the difference, if any, between a refugee and an asylum seeker.
Your Excellency, firstly, regarding the granting of diplomatic asylum, we do note that there is, at this point, uncertainty before the court on whether there is customary international law to grant diplomatic asylum at a consulate premise. However, Your Excellency, our response would be surrounding the fact that the respondent is bound by the non-refoulement principle under the Refugee Convention and also the ICCPR, regardless of whether the respondent is bound by the diplomatic asylum duty. But Your Excellency, on the second point regarding what is the difference, and yes, Your Excellency, on the second point, Your Excellency, what is the difference between an asylum seeker and also a refugee? There is a thin line of difference between these two, Your Excellency, but the difference is for the respondent is that this is only a procedural difference, whereby an asylum seeker would be granted asylum once he or she has gone through the process of refugee status determination of that particular country, and that person will be granted asylum. But in this particular case, Your Excellency, what is clear from the facts is that Ms. Vorman is indeed an asylum seeker, and this is because Ms. Vorman did indeed fulfill the two elements to become an asylum seeker or even a refugee. This is based on Article...
Sorry to interrupt. Just before we get too far away from the point, I want to make sure I understand your argument about whether diplomatic asylum exists under international law or not. You said that there's uncertainty before this court, and then you said we could determine this on the basis of other principles. Is that your position? Did I understand that correctly? And secondly, does the respondent take a position, even though this court has not taken one, on whether diplomatic asylum exists under customary international law or not?
Yes, I think for the first question, we submit that yes, our basis before this court is that the respondent is acting in line with the non-refoulement principle, which is a treaty law that governs both the applicant and the respondent. And on the second point, Your Excellency, even though this Honorable ICJ has never decided on this point before, we submit that this Honorable ICJ is not bound by any previous decisions as embedded under Article 59 of the ICJ statute, and therefore, Your Excellency, the authorities that we present before this court has nevertheless a persuasive value before this court. Your Excellency,
sorry, just want to clarify one more point. Do you, in order to demonstrate that there's been no violation of international law, Is it the respondent's case that this court need not take a determination as to whether diplomatic asylum exists as a matter of customary international law?
My apologies, Your Excellency. If I have understood your question correctly, the ICJ need not determine if there is a customary international law regarding this.
Sorry, the ICJ can determine. I'm asking on your case. So is the respondent's position that this court can decide this issue without taking a position as to whether diplomatic asylum exists under customary international law? Is that question relevant or irrelevant on your case? That's hopefully that's clear.
Thank you. We submit that it will be immaterial to our case, Your Excellency, because of the fact that non-refoulement principle itself is embedded under a treaty, which is the Refugee Convention. And we submit that Ms. Borman, under these 20 seconds, we submit that Ms. Borman is indeed an asylum seeker because she was suffering from a threat of persecution by the applicant state when they imposed a disproportionate charge of disproportionate punishment towards Ms. Borman. Your Excellency, I see my time is up. If I may conclude my last round.
Please do.
Thank you, Mr. President. For the last round, we conclude that Ms. Borman was entitled to a refugee protection because she suffers from persecution due to the disproportionate punishment, 20 years imprisonment, for only posting a tweet, and therefore the respondent does not have an obligation to return Ms. Borman to the applicant authorities. And with that, we thank Mr. President and Your Excellencies.
Thank you very much. We'll now hear from Ms. Batricia, if I'm pronouncing that correctly. Please take the floor.
Am I audible?
And
Yeah.
please proceed.
Right. Mr. President, Your Excellencies, may it please the court. My name is Amira Batricia and I represent the respondent, the Democratic State of Ranov in the case concerning the COVID-18 pandemic. I shall argue for 21 minutes on the matter of question 3 relating to the court's jurisdiction to hear the respondent's counterclaim, and on question 4 in regards to the applicant's violation of international law for shooting down a civilian aircraft. Your Excellencies, before that, I would like to lay out the flow of my arguments as for today, which is firstly we'll be mirroring the application that has been put forth earlier by the applicant. Is that firstly we will first address on the matter of domestic jurisdiction, and secondly we will address the matter of the first reservation, which is in regards to military activity, and then we will subsequently move forward to the fourth ground, which is on the application of the Chicago Convention in our current context. And we will also address on the point of right of self-defense, as has been put forward earlier. Your Excellencies, in regard to the reservation made, which is that this matter falls within the domestic jurisdiction of the applicant, we humbly beg to differ on that point, because the interpretation of what it means that has been fallen within the sphere of domestic jurisdiction is that a state, the matter that is to be decided in that case must not be decided in light of the principles of international law. And in our current...
I have a preliminary question on that, because we discussed with the applicant about the scope of the reservation and whether this court has jurisdiction to assess the extent, sorry, not jurisdiction, but whether this court can assess the scope of this reservation, or whether we have to rely on the self-assessment of the applicant and take the word on whether this is domestic jurisdiction or not. So I think that it would be necessary for you to address this point first in order to then allow this court to discuss the scope of the review.
Yes, Your Excellency, if I may address the question. We do agree that on the part of the second reservation which they put forward, that is, it falls under domestic jurisdiction. Most of state practice itself would indicate that this is a subjective evaluation of the states itself. However, this court may exercise the jurisdiction to review these reservation that was made and see whether the matter that has been brought forward before this honorable court can indeed be tried as pursuant to Article 36 paragraph 6 of the ICJ statute. And that is the matter for the court to decide. And it is also our contention that this domestic jurisdiction, yes, Your Excellency, if I may assist.
Yes, because what you said seems to me to refer more to an objective assessment on the side of this court of the scope of the reservation. Because if we follow what you just said, so we take a subjective approach, we should just take the word of the applicant, say whether they invoke this clause in good faith, and stop there. We should not assess whether this is indeed a case falling into the domestic jurisdiction or not. So could you please clarify your position in this respect?
Your Excellencies, if I may clarify, this reservation itself is mostly been decided according to a subjective evaluation, in that the state itself can decide on the matter. However, in our current context, hypothetically speaking, if this matter is to be further contested, saying that it should, the self-judging clause itself must be applied in accordance with the principle of good faith, hypothetically speaking, this applicant does not satisfy the requirement, because there is a doctrine of abuse of rights in which it allows, it confers that the owner to whom this discretionary power has been given must exercise this principle in conformity with the spirit of the law, which is to serve justice on behalf of the people of whom their rights has been taken away from them. And however,
Agent, I'm sorry, but I'm still struggling to understand what our role is in this case. Should we assess whether the applicant invoked the reservation in good faith, or should we assess whether, from an objective point of view, this is a matter of domestic, falling within the domestic realm?
Your Excellency, on that point, allow me to address this question and move on to the first reservation, which is on military activity. In that, this domestic jurisdiction itself is, even though it is, there are certain things that the applicant state would have mentioned they deem to have fall under the domestic jurisdiction of their state itself. However, the sphere of this domestic jurisdiction cannot be interpreted just based on the fact that what the state of the applicant simply say, because there are certain aspects in our case in due regard, which is that this is a matter which is in violation of the Chicago Convention, which is a principle of international law, that an international obligation that they have been breached. Therefore, that reservation could not be used in order to limit this court's jurisdiction. Yes, Your Excellency.
I could understand the argument if what we were dealing with was something other than a reservation to the court's jurisdiction. So, for example, if this was a self-judging exception to the application of a treaty, there might be an argument that treaties must be performed in good faith, and therefore the self-judging exception must be invoked in good faith on the part of the state. But here, what we're looking at is a reservation to the court's jurisdiction. How would we have jurisdiction to assess the good faith of a state in deciding whether or not a matter is within the court's jurisdiction when it's made a reservation like this?
Your Excellency, I believe that is it is not our argument that this is subject to the principle of good faith. However, hypothetically speaking, if I could address the question, is that under the principle of good faith, there is a particularization, which is one of the particularization would be the doctrine of abuse of rights. And under that doctrine, if the owner of this right has not been exercising their discretionary power that has been granted onto them in conformity with the spirit of the law. Therefore, that indicates that they did not apply this principle of good faith in the manner in which it should.
Agent,
And,
but I think what the President of the Court is saying is that if this is a self-judging reservation, and if we agree with that proposition, then we must stop here, because you're inviting us to say this is a self-judging reservation. However, you, the court, need to determine whether it is invoked in good faith or whether its invocation is an abuse of right. And the question is, can we take that second step if it is indeed a self-judging reservation? Because once we determine it's a self-judging reservation, we must stop there. The applicant has determined, he's made a determination according to that reservation. What is it that allows us to question that determination and inquire into whether it's made in good faith or in bad faith?
Your Excellency, in regards to it, the application of principle of good faith itself, there are cases such as Djibouti against France, whereby it indicates that such reservation, even though it has been put forward by the state as having fallen within, they themselves are the one who's supposed to judge whether that falls under their domestic jurisdiction or not, it itself would it still allows the court to analyze that further if this matter is indeed falling under the domestic jurisdiction. And Your Excellency, if I move forward to the first reservation, which is the military activity aspect, it is our submission that this is actually a law enforcement activity and not a military activity. This is because we would like to draw a parallel between our current case and the case of Ukraine against Russian Federation, whereby in that case, an objective assessment has been conducted in order to show whether this is a military activity or a law enforcement activity. And in that case, the decision that was come to was that it was a law enforcement activity, and this was judged based on the activity preceding the shot that was taken by the Russian Coast Guard.
Agent, but in the present case, all the activities preceding the shooting down of the aircraft were led by the military. So this was a military organized action led by military officials in response to a terrorist threat. So the factual circumstances of these two cases appear a bit different.
Yes, Your Excellency, if I may address that question in 2 points. Firstly, in regards to the an involvement of the military forces in the activity itself does not automatically conclude that this is indeed a military activity, because as has been indicated in the case of Ukraine against Russian Federation, the mere involvement of the military forces in the activity in question does not automatically reverts us to that conclusion only. There are other aspects when we are conducting this objective evaluation that this could have fallen under a law enforcement activity, or this could have fallen within military activity. And these 3 aspects that are being taken into account is the intention of the parties when conducting the activity in question. And in this case, we would indicate that the only purpose when it was dispatched, the fighter jet was dispatched, was to obtain the identification of the aircraft in question, and if needed, it could be intercepted. And the second part is that there needs to be, my apologies, Your Excellency, there needs to be, we have to take a look at the manner of deployment itself. And again, it was deployed to ascertain the identity. And the third requirement that we must take a look at is the manner in which the parties engage with each other when they were side by side. And in this context, we are submitting that there is no military build-up, there is no any hostile act that was done by the civil aircraft when it was intercepted by the fighter jet. Yes, Your Excellency.
agency, we heard from the applicants that this was an armed attack by a non-state actor. And in such case, that wouldn't be, there wouldn't be any direct engagement with your state, as you're saying. So how do you apply this third arm to the test, taking into account the fact that there was or at least the threat of an armed attack that was being responded to?
Yes, Your Excellency. In regards to armed attack itself, an armed attack is being defined as acts of armed force that is made against a state, either by another state or an armed band itself. And in our present situation, the aircraft itself has not been acting in a hostile manner. They did not conduct any evasive maneuvers that would endanger the fighter jet, the pilot in the fighter jet itself. And they did not even avoid the fighter jet at any cost. They just resumed their path. Yes, Your Excellency.
I mean, we know this in hindsight, but did they know this when they took the action, when they decided to fire at the airplane? Because at that time, it seemed quite menacing. They had information about the impending terrorist attack. The airplane did not respond. It was not identified. It was very close to the capital.
Yes, Your Excellency. The answer we could find in the second element in regards to the invocation of right of self-defense, which is on the part of it being imminent. Right. The threat itself must be, as has been put forward by the applicant, that it is imminent, it is immediate, as the travel distance between the aircraft itself and the capital city is quite near in terms of time-wise. However, Your Excellency, it should not be the information that was obtained by the applicant was just one aspect, which is based on a credible source, which is the Interpol. However, that is the only source that was obtained by them, and that in itself cannot say for sure that this attack or this threat is imminent, because that only amounts to a suspicion. And in order for states to undertake or use force against a civil aircraft in flight which has trespassed over their airspace, it must be on a basis of certainty. However, all of the circumstantial evidence in our present case does not point to an irresistible conclusion that that particular aircraft is indeed going to undertake any terror attack against the applicant. Yes, Your Excellency.
I fear that we have seamlessly flowed from jurisdiction to the merits without really getting to the bottom of the question of military activities. For purposes of the court's jurisdiction, do I understand correctly that the question presented is whether the shooting down by a fighter jet of an aircraft was a military activity? And if so, can you please explain to me how that can be viewed as law enforcement?
Right, Your Excellency, my apologies for being so abrupt in answering the question. Your Excellency, no, the mere involvement of a military force in the activity does not automatically point to the conclusion that it is a military activity. This is because, if I could draw a parallel to the case of Ukraine against Russian Federation and our present case, in that case, in the Ukraine case, the first act that was conducted was they conduct radio communication. And similarly, the first act that was conducted by the applicant was conducting that radio communication. And the second act that was done by the Ukraine.
I'm sorry, the claims presented in this case concern the radio communications, or do they concern the shooting down of the aircraft?
It concerns the shooting down of the aircraft, Your Excellency. However, in order to determine whether this is a military activity, one must take a look, an objective evaluation of the case, and it must be done based on analysis of the acts preceding to the shooting down itself. And the acts preceding to the shooting down is conducted in three phases, which is firstly, radio communication. Second, they had conducted visual signals to indicate to the aircraft that they are being intercepted. And thirdly, they fire tracers across the flight path. And similarly, in the case of Ukraine against Russian Federation, in which the tribunal held that it is a law enforcement activity, first, the Russian Coast Guard, what they did was conduct radio communication, and then second, they fired the signals to indicate that they have indeed been intercepted. And then, after all that has been done, the shot was taken to shoot at these Ukrainian naval vessels. And based on these facts, Your Excellencies, we can see that if in the Ukrainian case itself indicates that all of those measures preceding to the shot is a law enforcement activity, what we can also draw parallel to in our case is that if it was done in a similar context and not for carrying out any purposes in regards to military function, then this is supposed to be indicates that this is a law enforcement activity. Yes, Your Excellency.
While we are on the matters of jurisdiction and admissibility, what is the harm suffered by a respondent as a result of the shooting down of the plane?
Your Excellency, on that point, firstly, echoing from the submission of my co-agent, is that the person who is on board of the aircraft itself is someone of whom they sought asylum from us in the first place. And even if that argument does not convince this honorable court, we invoked our right under Article 48 of the Articles of State Responsibility, whereby it allows for members, contracting parties of the same as the applicant, which is in this case the Chicago Convention, to bring forward a case, a claim against them on the basis that they have acted in contravention with the common interests of the contracting parties of the Chicago Convention. Whereby,
so your claim on this point is for violation of the Chicago Convention?
Yes, Your Excellency. Yes, Your Excellency. And with that said, Your Excellency, if I may resume my point, seeing that my time is almost up, on the part of proportionality, it is our submission that the shooting down of the aircraft itself is not proportionate, and this is because it is our submission that instead of shooting the aircraft at its wing root, they could actually took that shot at the wing tip itself. This is because according to the Journal of Aerospace Engineering, on the particular study was that the method for assessing combat survivability for aircraft with wing damage, it states that if the damage has been moved to the tip, it would reduce the magnitude of lift loss and the drag coefficient would increase. Therefore, Your Excellency, if this mean is available for the applicant to undertake, but they instead chose to take a shot at the wing root area, it is not proportionate as the means would have been satisfied if shot at wing tip. With that, Your Excellency, I thank this court for its time and indulgence.
Thank you very much. We'll now hear rebuttal from the applicant. Which of the applicant's speakers will take the floor? Excellent. Please proceed.
Your Excellencies, the applicant's rebuttal submits two key arguments. The first one regards the respondent's discriminatory entry regulation, and the second one regards the respondent's assumption of there being a threat to persecution towards Ms. Foreman because of the penalty the prosecutor was seeking. As to the first argument, the respondent has sought to rely on Article 4 of the ICCPR to issue what is considered to be a discriminatory entry regulation. However, the applicant submits that the general comment number 18 regarding non-discrimination states that in paragraph 13 that differentiation will be considered discrimination if the criteria for such differentiation is not reasonable or based with the objective criteria. As of the 15th of May of 2018, 23 days after the entry regulation was enacted, no country in the region or Khan of Style, neither Khan of Style nor Afropluia had any suspected or confirmed cases of JV-18. Therefore, this differentiation is not sustained by objective criteria, and thus constitutes discrimination. As to the second argument, the respondent submitted that Ms. Wong was being persecuted because she was prosecuted to the maximum penalty before the prosecutor. However, the applicant submits that Aperplea is a democratic state that respects human rights and the rule of law. Furthermore, there is nothing in the statement of agreed facts that indicates that her right to due process was in question. She would still have the right to appear before an impartial set of judges in a court of law. She would still be informed of the nature and the cause of the accusation, and most importantly, she would still have a right under a democratic state to appeal. Thank you, Your Excellencies. May it please the court.
Thank you very much. We will now hear rebuttal from the respondent. Please take the floor.
Am I audible?
You are indeed. Please proceed.
Mr. President and Your Excellencies, the respondent has 2 points of rebuttals. Firstly, the applicant submitted that the differentiation based on the nationality of the applicant and the respondent is unreasonable and is therefore discriminatory. However, Your Excellency, the respondent respectfully disagrees with this because, as we have submitted earlier, this is not an issue of discrimination. Rather, this is an issue of to whom the respondent owes an obligation for the persons to be returning to their own country. And this is embedded under Article 12, Clause 4 of the ICCPR, to which it is clear that the respondent owes an obligation for their own nationals to return to their own country, which is the respondent, but this is not equal for permanent residents, Your Excellency, because factually it is absent that these permanent residents have their special links, such as speaking the language of the respondent and also living their entire life in the respondent state, which is a very, very high threshold to meet, as stated under the case of Warsame in Canada. Your Excellency, moving on to the second point of rebuttal, whereby the applicant had submitted that Ms. Warman was not being facing persecution because of the applicant's state having a history of good upholding human rights law and also upholding the rule of law. However, as you see, we respectfully disagree with this because based on the facts itself, it mentions under paragraph 32, whereby Ms. Warman was charged with a 20-year imprisonment for only merely posting a tweet, Your Excellency. And this tweet turns out to be true. The contents of the tweet is true, which has saved the public health between both the applicant and the respondent state. Based on this fact itself, Your Excellency, it shows that the applicant has failed to secure the human rights of the Ms. Warman, and therefore we conclude our rebuttals. Thank you.
Thank you very much.
The Honorable Court is now adjourned. Agents for the applicant and respondent, please remain in this room while the judges deliberate in the judges' room. Thank you.
Dear Team 302, you were great. Congratulations.
You guys are great.
Bye.
It's amazing.
Wait, you guys are from Portugal, right?
Yeah,
I'm wondering, like, what time is it there right now?
it's 5 o'clock in the afternoon, but Carolina is speaking from Brazil. What time is it there?
It's 1 in the morning.
We're great. Like, thank you for being up at this time. It was a great match.
Yeah, for sure. Congrats.
The feeling is mutual, that's for sure. And yeah, I'm not sure. I'm just lucky enough to be here to face you guys because I don't care if I win or not. What's important is that I learn from my
Oh, that's true. Thank you. We feel the same.
We feel the
We
same.
feel the same. It was a privilege. Thank you very, very much.
You guys have a great day. Yeah.
again, be careful with that.
I am.
We don't want another car incident. We can see you. But no, I won't solve it.
Huwag ka pa kung phone.
Just legal out court.
Will the teams please return? The judges will return very shortly. So we want to make sure that everyone is here. Thank you. I'm actually going to ask all of the competitors to unmute themselves shortly before the announcement so that we can get an authentic reaction, so to speak. But for now you can keep yourself muted. That is quite alright. Just 1 second. The honorable judges are making some last adjustments, and they will be with us very shortly. I will actually use that time to remind both teams that the champion will be announced here by the bench, whereas all of the other awards are going to be announced at the closing ceremony, which starts in exactly 1 hour and 9 minutes. All right, the honorable judges are now ready to re-enter the room and render their final judgment. Well, you could rise physically, you know. Or not. Mr. President, Your Excellencies, I am told that you have reached a final conclusion about today's proceedings. Before you render your judgment and before you give your feedback to the teams, I would like to express the profound gratitude and appreciation of Pierre, Thiago, and myself for your participation in this final, as well to all of our judges from the preliminary rounds and the semifinal rounds, as well as to all the teams that took part in the competition, and to our dear sponsors from America for Bulgaria Foundation, Denton's Paris, White & Case Paris, as well as the US Embassy in Bulgaria. Thank you very much, and now I yield the floor to the honorable judges.
It's been an extraordinary day of advocacy, and we've very much enjoyed listening to the advocates plead. Before delivering the decision, it's only polite for us to introduce ourselves to you so that you know who's been judging you. I'll begin. My name is Bart Legum. I'm a partner in the Paris office of Denton's and global co-chair for litigation and dispute resolution of the firm. My practice is about half and half investment treaty arbitration and commercial arbitration. Earlier in my career, I was a lawyer for the State Department, where I acted as lead counsel for the US government in the first investment arbitrations under the North American Free Trade Agreement's investment chapter. And prior to that, I was a commercial litigator at a New York firm. So with that, by way of introduction of myself, I'll ask Kristen to take the floor.
Hi all. I am a partner in the International Arbitration Group at Weston. Like Bart, I sit in Paris. I also practice investment and commercial arbitration. I'm a former Jessup alum, having participated more than 10 years ago now on behalf of the University of Ottawa in Canada.
Great. Agnese.
Good evening, everyone. So, my name is Agnese Pizzolla, as you can read. I am a senior legal counsel at the European Central Bank, where I work mainly on banking and banking supervision matters. Among the various things that I do in my professional life, I also have the honor and privilege to act for the European Central Bank as agent before the Court of Justice of the European Union. And this is where my Jessup training comes really at hand most of the time. I have a long history with the Jessup. I started more than 10 years ago as well as a competitor. Then I was a coach for my university team for a few years. Then I started judging the competition in 2010, and I've been judging national and international rounds since then. And last but not least, I am also the national administrator for the Italian national rounds. So I usually tell to the teams that I judge that I'm one of those people who took the invite to come back to the Jessup very seriously, and I always invite the teams that I judge to do the same. So thank you for your presentation today.
And now over to you, Stanimir.
Thank you, Bart. My name is Stanimir Alexandrov. For about 20 years, I was with the international practice of Sidley Austin LLP in Washington. The last 10 years of that, I was the global co-leader of that practice. And I was involved mostly in international arbitration, of which mostly investor-state arbitration. However, I was also involved in domestic litigation in the United States, as well as arguing about a dozen cases before the World Trade Organization and a few cases before the International Court of Justice, although on background. For the last 3.5 years, I've been a solo practitioner focusing on work as an arbitrator in various types of international arbitration disputes, mostly investor-state, but also international commercial arbitration disputes. And it's a pleasure to work with my colleagues on the same court and listen to the very able presentations of the participants. Thank you.
Thank you. And over to you, Nikolai.
Hello to both teams. My name is Nikolai Ilchev. I'm a director in the tax practice of PwC in Bulgaria. In my former life, also more than 10 years ago, I participated in the Jessup. Then I was coaching my university's team for 5 years, and I've been judging national and international rounds of Jessup since 2016. And I want to congratulate both teams for the excellent presentation they made today.
Great. Well, I think the time has come for us to announce our decision. After I make the announcement, I will give the floor to my colleagues one more time for them to provide comments. But the result that we have come to unanimously is for the applicants. So bravo to you, and bravo to the respondents as well. It was a very difficult decision. We felt that the two teams were very evenly matched, and so there is cause for pride and celebration on both sides. So with that, by way of general background, let me again ask Kristen to take the floor.
Congratulations to the applicants and also to the respondents. It was a very evenly matched round and very well deserved. I have no doubt that both teams will do very well in the global rounds. What I wanted to do today was just pass along 3 tips, 2 substantive and 1 about the Jessup generally, that I encourage you to take forward in the global rounds. The first is you all had very good roadmaps at the beginning of your presentations, but I wouldn't hesitate to already start developing some themes, some key arguments. So instead of just setting out your arguments, to add a little more flavor, to color the position in terms of, are you fighting for justice? Has there been some egregious wrong? Just to sort of capture the attention of the judges right from the get-go and go forward from there. I think that that will make a very big difference in sort of the first 2 minutes of your presentation and how the initial impression that you make. And you'll see that such a strategy is very common at the international Jessup rounds. The second thing I wanted to pass along was to really focus on the judges' questions. I've judged many Jessup rounds now, and judges always remember very closely the questions they asked and the answers that were given. Indeed, they remember this as much, if not more so, than the various arguments that you present. You all did a very good job, but you should ensure that you listen carefully to each question and answer as directly as possible. There were a few instances across all 4 of you today where you didn't like the question very much, or the answer wasn't very good for you, and you're all going to get questions like that in every round that you do. And you need to give an honest answer and a direct answer before you move on to other arguments and focus on your positions. The other thing I'll say is if you don't know the answer to a question, that's perfectly fine. You should acknowledge that you don't know the answer to the question and then move on. But that's a very important part of the Jessup, and I encourage you to keep practicing and to really focus on the questions in the international rounds. The third, less substantial comment is I just wanted to really encourage you to participate not only in the rounds, in the global rounds of the Jessup, but also all of the other social events. I know that they're virtual this year, and that's really difficult, and we've probably all had enough webinars at this stage in our lives, having done for 18 months. Or I guess 12 months, a little over 12 months now of our virtual world, but I would really encourage you to participate. I sit on the board of the International Law Students Association, which is organizing the Jessup. There's some very fun things coming your way, and I really would encourage you to take the time to participate. The people you will meet, I promise you, will be important both personally and professionally in your careers going forward. So I really would encourage you to get the most out of it, even though we are stuck in our virtual world this year. Thank you again, and congratulations to all.
Over to you, Agnese.
Thank you very much. So I also have a few points, and I think that they are of value for both teams. The first one, and I build on what my colleague on the bench just mentioned, relates to roadmap. it's true you had a really good roadmap at the beginning, both teams. You tend to lose it though throughout your speech. It's true that you face a 5 judges bench, which is particularly cumbersome because this means that you also get more questions and you get questions from different people. So it's definitely more challenging for you. But sometimes I got the impression that you were trying to navigate whatever situation was in front of you and you lost the direction. You had not full control on the discussion. And this is a tricky thing in the Jessup because, of course, our questions will always put you out of the way, but it's your job as an oralist to get back to your track and try to present the arguments that you think are important for us to listen in order to decide on your case. And this leads me to the second point, which is time management. Both teams struggle with that. And time management is important not just because you have 22 minutes and we want you to talk about the 2 points for 11 minutes each. Time management is important because you have many things to say, and better you manage your time, more things you manage to address in your speech, more arguments you manage to raise, and more interesting your presentation is. If you get stuck in discussing the same item for 10 minutes, there is a lot of the work that you did in the Jessup during the preparation, which is not going to be expressed and is not going to be communicated to the judges. So please try to take an eye on the time and try at least to move and not to get stuck in discussing the same item over and over, even when judges want you to stay on that topic. Of course, then we are aware when it's our fault and when it's not. So please at least try to maintain control on your roadmap and on your time. Another thing that was already mentioned, but I want to stress it again because it's extremely important, is question and answers, especially when it comes to yes and no questions. We had few instances today in which both teams had issues with that. And the point is, when you get a yes and no question, the first thing that has to come out of your mouth is either yes or no. Because especially when judges stress the fact that they are asking a yes or no question, your answer should be yes because or no because. Having this said, congratulations to the winner and congratulations to the runner-up team. I think both teams did a really good job. Your presentation today showed how much work you put in the Jessup in the last months. You still have a lot of work to do in terms of rounds because the global competition will start next week. Please take advantage of all the opportunities that ILSA will put you at disposal in order to meet teams from other jurisdictions and to at least try to enjoy part of the social element of the Jessup, which this year it's unfortunately affected. But we are all trying to do the best with the instruments that we have, and then come back to the Jessup. And hopefully next year we will have an in-person Jessup, so you can also meet all these wonderful people in person. And I wish you best of luck for the global rounds. Thank you very much.
Stanimir, over to you.
Thank you, Bart. Well, I'll start by saying you all did extremely well. In fact, better than some of the real-life lawyers I've heard in real-life situations, and that I give you all a lot of credit for your preparation in your delivery. There is little I can add to what my colleagues already said, I would say two things. One is to emphasize the point that if you get a question from a judge or an arbitrator, you address it head on. You give a straightforward answer. If it requires an explanation, you give the explanation, and then you move on, because a question from a judge is the best thing that can happen to you. This is what gives you an idea of what they are interested in, and they give you an opportunity to persuade them because they hesitate, excuse me, or because they are not convinced by a certain point. And so you take this opportunity. You don't move on. Think of it as an opportunity, not a difficulty presented to you. And the other point I want to emphasize is you need a little bit more self-confidence. You know the case much better than anybody sitting on the panel, because you've spent innumerable hours, and the judges in any situation have spent less than you have. And so you need to be more confident when you present the facts and the law, because sometimes it's body language, is the way you speak that conveys hesitation or uncertainty, and you don't want to convey that. Even if you're not yourself persuaded in the correctness of the answer, you need to present it persuasively. That's your job. Thank you, Bart.
Thank you, Stanimir. And now over to you, Nikolai.
I don't think that there is much that I can add to all the feedback that has been given so far. I concur fully. And again, to reiterate, I mean, everybody said these questions. Be happy when you receive questions, because we as judges know that you can be in front of us and have a 22-minute speech. What really shows how well prepared you are and how really well you know the law is your answers to questions. So every time you receive a question, think about why the judge is asking me this question, what's behind it, what is his real concern, and try to address it in the best way possible, directly, and then use this to move on to the rest of your argument in the best way. Congratulations to both teams. I think that you did really, really well, and you have a very bright future in the global rounds. I wish you best of luck.
Great. And at this point, of course, almost everything that has been said, that can be said has been said. The only additional point that I might make is that there's a real benefit to using simple, short answers to questions, to the extent that you can do it. Some people think that the job of a lawyer is to be eloquent and to give long, kind of extended, nice-sounding answers. What judges are really looking for is short, direct answers to their questions. If you can do that, then you not only satisfy them, you also keep more time for you to make the points that you planned on making, and to get other questions from judges that might allow you to persuade them. So one may have the impression that that flowery or extended answers are useful. They're not. It's really best to be short and to the point. And with that, I will turn it back to Evgeny for the remainder of the ceremony.
Thank you very much, Bart, and thank you very much everyone else who joined this event. We're actually not going to be doing the rest of the ceremony here. We are doing it on Zoom, and I would like to use this opportunity to invite our judges to join us as well. It starts in about 45 minutes. Feel free to tag along. We will be giving a few very special awards, and we're going to share the story about how these rounds came to be. So if you can, we will be very glad to have you. You should have received the invitation via email.
Before we do sign off, would it be possible for for the judges to know where the teams are from?
Yes. Now that the match is concluded, yeah, I'm sorry. I give the floor to the applicant to present themselves.
Thank you, Your Excellencies, for the valuable insight, and congratulations to the opposing team. You are great competitors. We feel very fortunate to have the opportunity to share the floor with Team 302. Thank you very much. We're from Portugal. Hurrah! We're from Portugal, Lisbon.
Thank you all. Thank you so much.
Fantastic. And the respondent, please.
Hi, Your Excellencies. We are actually from Malaysia, and it's 1 in the morning right now. But I can honestly say this is the most life-changing experience for me personally, and I believe for my team as well, because thank you to these virtual rounds, we are able to meet such great people, and Your Excellencies have given very insightful comments to us for the global rounds. And we heartily congratulate our learned friends for winning first place, and thank you once again for this opportunity.
Great. Well, thank you for that. So back to you, Evgeny.
Yes, I actually took the liberty of posting the Zoom link here in the chat for your convenience. So as I said, in 45 minutes we're going to kick off, and please do come if you have the time. That will be great. And without further ado, I will now like to again thank the teams and the judges, and we declare the 2021 Jessup Intercontinental Friendly Rounds finally to a close. Thank you very much.
Thank you all.
Bye, guys. Thank you very much. Bye.
Bye.